more.
Yeah. Yeah.
Okay. Bruno, and then there's a second question that we have today. This one's generally just a little bit more of a general sort of question that we've received. And basically it's an investor who's looking to do a development, but he's considering two properties that are situated next to one another, you know, and owned by different owners in the circumstances. So he's got to try to figure out a way to get himself in a position where he can deal with both of these particular properties. And the question is basically just some general strategy on ways in which he can formulate a way in which both properties can be dealt with. You know, can he consolidate them, you know, or are there other ways in law of dealing with a problem like this?
Sure. Thanks so much. So we actually deal with this quite a bit, especially from a development side. So the first thing is, I'm not a town planner, so I'm not proclaiming to know anything about town planning. And as I understand it, if you're going to do a development that crosses over certain lines, typically what a lot, especially from a zoning perspective, because if you need to rezone the property, you're going to need to rezone the entire property. So what a lot of developers do is they do a consolidation of the two properties, put it into one, and they do the rezoning of that one big property, right? So they can, whatever it is, whether it's a commercial development, retail center, flats, residential, whatever the case is. So that's the first thing. So typically to do a consolidation of the two properties in order to be able to rezone and develop on them, you would have to be the same owner of the property. And that's what I get from the town planners. So I'm not going to lie to you, there might be an exception to that, but over all these years, it's just been an accepted principle that you only consolidate if you're the common owner of both properties. So that deals with the town planning component. And then obviously the conveyancer, once all of this is done, and the conveyancer is the one that registers the consolidation. So that's when we kind of jump in as lawyers to try and assist. Now, from a strategic perspective, all the ones that I've dealt with when it comes to this, there's been questions, for example, on how do I actually structure the deal to make things like this work? And typically you get this question when it comes to co-developments. So that's when you want to involve the existing owners in a deal, and you know, they're going to get something out of it. So that's this is now a structuring question. So it's either that, or for example, I've got a bunch of developers or businesses that actually own multiple properties, either in different entities, or they had it with different partners, and they're close enough that they want to now consolidate these and put them together and create something with them. And now they're trying to figure out, again, how they're going to structure this. So I just thought I'd throw it out there, and maybe we can have a better discussion with this over time, because I mean, just this explanation, the town planning thing probably took up most of the time. But a lot of the people then approach me and go, well, okay, great, we just transfer the property. So even if it's a co-development, I buy from X, I then move it into this company and I give X shares in that company. The downside with doing stuff like, so there's an upside, and the upside obviously being the fact that at least you sell the property and it's out of these owners' names. And if you own all these properties and you move them into a single entity, you move them into a single entity. But the downside is there's a lot of costs associated with it. So aside from the transferring costs and possible bond cancellation and registration costs, you're looking at having to now make provision for things like capital gains, transfer duty, and or VAT before these properties can even be moved. And so what I do for some of these clients is I use some of the provisions in the Income Tax Act to be able to defer the payment of taxes. And now we spoke about this briefly, but under different contexts. So there we were speaking about people taking and restructuring their personal affairs. So we're still speaking about structuring, but now we're not looking at it from a estate planning or wealth planning perspective where it's fixed your estate. We're looking at it from a development perspective. So if you're getting into a co-development with someone, you could very easily transfer the property into a common entity and issue shares to this person in favor of that entity, so that he actually holds shares in that company. And that would then give him, obviously, the shares that he wants, the security that he wants, he wouldn't actually now get paid for the property just yet. He'd now be part of the venture. And it would save yourself the hassle of, number one, paying a purchase price, because now you're doing a co-development, but it would save him the hassle of having to account for capital gains tax, you probably having to account either for transfer duty or VAT or whatever the case is. In the other examples, for instance, where the clients own different properties in different entities, same thing applies. So instead of trying to sell the properties across into one common entity, you could have this single entity issue shares in exchange for the properties, and all these other companies that the guy has just becomes like a shareholder. And you have one common company, you have all the properties sitting in a common company, and then in this holding company, you've got all the multiple shareholders. But like this, you can do it without having to pay transfer duty or VAT, because on one transaction that I'm working with now, it'll be a VAT transaction. And that obviously now means that, yes, you need to pay VAT, and sure, you can claim it back, but how long is it going to take for you to actually be able to get the VAT from SARS? If you can't zero rate it, so if you can zero rate it, at least you've got that. But if you can't for some reason, you're going to need to pay it and then claim it back. So I would definitely look at, if the genuine intention is to keep the same kind of parties interested in a deal, just use like your Section 42 provisions of the Income Tax Act to move these properties around. It's a hell of a lot cheaper. Remember, it defers the tax, so it doesn't mean that you don't pay it. It just means that you now won't pay it. Eventually, when this holding company decides to get rid of the property, that's a different, that's a different day.
Yeah, and I think the important thing with all these things, as you say, is as much as there are a lot of different ways that you can structure this, it does come down to the individual situation again. That classic, the answer to every legal question is it depends. It depends every single time. But absolutely. It's keep on top of it. You got to think of clever ways to handle these situations, no matter what comes.
Sure. No, absolutely. Thanks so much, Nick, and thanks for everyone. And yeah, we'll see you guys again next week.
Okay. Thanks, Bruno. Have a good one.
Cheers. You too.
All right. Cheers.